Um, so thanks for one more person's coming in, but there we go. Okay. Thanks for your understanding about the how the schedule fluctuates, and all based on good things that uh, a new grandson in my family, and wanting to be with my daughter and son-in-law to celebrate the bris last Tuesday. So all's well. Poo poo poo. So, in case you haven't heard, my grandson's name is Eyal Rubin. And okay, enough about me. And so, what I wanted to talk about today, which I didn't advertise ahead of time, is the International Court of Justice and its opinion about is the supposed well, South Africa um, submitting an application to the International Court of Justice, claiming that Israel's army is perpetrating genocide in Gaza. And I don't want to read, I don't want to share the court's opinion. I wanted to share the Israeli judge who's added to the court for this special circumstance, Judge Aharon Barak, the former chief of Israel's Supreme Court, retired, and was added here and wrote a 10-page opinion that is published as part of the proceedings that were published this past Friday. Significant that this past Friday, the day before the International Holocaust Memorial Day. Friday, January 26th, the International Court of Justice issued a preliminary opinion, and also the opinion of two justices. The Ugandan judge also was a dissenting opinion to the majority opinion, and that Ugandan judge has since been the government of Uganda separated itself from its justice and her opinion. And then it was Aharon Barak's opinion. So I'm going to share my screen, and you can, I found this just by Googling Aharon Barak, or I didn't even do that, Justice Barak, International Court of Justice. And I'm going to be sending out an email later, my Israel update, and I'll have this link in there, as well as a Wall Street Journal article about United Nations Relief Work Agency and its scandal, and also an interview with that the Wall Street Journal had with Prime Minister Netanyahu. So lots of interesting things, but I wanted to focus on this. If you what you originally when you go to Google Justice Barak International Court of Justice, a another edition of this comes up, but a PDF. There's a link to the PDF, and the PDF makes it a lot neater, putting the footnotes in a better order. So that's what we're looking at, and you'll see. I'll be sending out the link to this PDF a little bit later. Okay, so this is what he's called in the for this specific case, Judge Ad Hoc Barak. So he's not a member of the regular justices, the panel of justices. He's added to the panel of justices, just as South Africa was able to add a justice as well, just the way the court works. So I'm not going to read the whole thing, but there are a couple of things in background that I wanted to share. And then what he also says at the end, which in legalese you'll see, essentially makes a mockery of the whole proceeding itself. Okay, so this is what Judge Aharon Barak said. South Africa came to the court seeking the immediate suspension, I'll make it a little bit bigger. Let's see, but I want to be able to move it over to see it. I can't. I'm sorry. I have to make it just like this. South Africa came to the court seeking the immediate suspension of the military operations in the Gaza Strip. It has wrongly sought to impute the crime of Cain to Abel. The court rejected, right? You get this, it's just, he starts right out with a biblical reference to the book of Genesis, right? The two brothers. And, right, it's so, in other words, the crime of Cain to Abel. So Abel is the one who was killed by Cain. And so Barak says right away, right? And then Cain says to God, am I my brother's keeper? I don't know what happened to Abel, but Cain killed Abel. We don't know why, but Cain killed Abel. So Barak says, what South Africa is trying to do is to say that the reverse of what's going on, right? So to claim that Abel killed himself. Okay? So it has wrongly sought to impute the crime of Cain to Abel. The court rejected South Africa's main contention and instead adopted measures that recall Israel's existing obligations under the Genocide Convention. The court has reaffirmed Israel's right to defend its citizens and emphasized the importance of providing humanitarian aid to the population of Gaza. The provisional measures indicated by the court are thus of significantly narrower scope than those requested by South Africa, right? The court said preliminarily Israel's not outwardly doing, is not outwardly committing genocide, but Israel should try to do the best it can to refrain from as much civilian casualty as possible. Okay? Notably, the court has emphasized that all parties to the conflict in the Gaza Strip are bound by international humanitarian law, which certainly includes Hamas. The court has also stated that it is gravely concerned about the fate of the hostages abducted during the attack on Israel on 7 October 2023 and held since then by Hamas and other armed groups, and calls for their immediate and unconditional release. Okay, so all good things here, right? Pointing out that the court does is gravely concerned about the fate of the hostages. Okay, so this is mainly what I wanted to share first, how important it is to have on the record in the United Nations International Court of Justice this autobiographical comment from Justice Barak. The Genocide Convention holds a very special place in the heart and history of the Jewish people, both within and beyond the State of Israel. The term genocide was coined in 1942 by a Jewish lawyer from Poland, Raphael Lemkin, and the impetus for the adoption of the Genocide Convention came from the carefully planned and deliberate murder of 6 million Jews during the Holocaust, right? So the whole idea of genocide that Barak is reminding the court and reminding then the world, because this is a public document, that genocide exists as a legal term because of what the Nazis attempted to do to us 80 years ago. I was 5 years old when, as part of Operation Barbarossa, the German army occupied the city in which I was born, Kaunas, in Lithuania. Within a few days, almost 30,000 Jews in Kaunas were taken from their homes and put into a ghetto. It was as if we were sentenced to death, awaiting our execution. On 26 October 1941, every Jew in the ghetto was instructed to gather in the central square known as Democracy Square. Around 9,000 Jews were taken from the square on that day and executed by machine gun fire. There was constant hunger in the overcrowded ghetto, but despite all the difficulties, there was an organized community life. It was a community of individuals condemned to death, yet in their hearts there was a spark of hope for life and a desire to preserve basic human dignity. At the beginning of 1944, so this is 26 October 1941, so 2.5 years later, the Nazis rounded up all children under the age of 12, loaded them onto trucks, and shot them during the infamous Kinder Action. It was clear that I had to leave in order to survive. I was smuggled out of the ghetto in a sack and taken to a Lithuanian farmer. A couple of weeks later, my mother and I were transferred to another farmer. We had to be very discreet, so the farmer built a double wall in one of the rooms. We hid in that narrow space until we were finally liberated by the Red Army on 1 August 1944. Only 5% of the Jews of Lithuania had survived. Okay, so this is his survival story. 6 months, 7 months in hiding with his mother behind a wall, a double wall in a farm. Genocide is more than just a word for me. It represents calculated destruction and human behavior at its very worst. It's the gravest possible accusation and is deeply intertwined with my personal life experience. So it's a chutzpah, Barak is saying, to claim that Israel has perpetrated genocide. He's about to make the case for Israel, but he's saying the history of the term genocide is Jewish and relates to the extermination of 6 million Jews in Europe by the Nazis. And it's personal because he was almost one of those 6 million. He and his mother were almost part of that 6 million. So to claim genocide becomes a personal claim to him. Okay, so I have thought a lot about this. I have thought a lot about how this experience. All right, just making sure everybody's still muted. I'm sharing this Justice Aharon Barak's opinion that was part of the International Court of Justice, just published this past Friday. I've thought a lot about how this experience has affected me as a judge. In my opinion, the effect has been twofold. First, I am deeply aware of the importance of the existence of the State of Israel. If Israel had existed in 1939, the fate of the Jewish people might have been different. You know, this as I'm reading this again out loud now, after I read it earlier this morning, it's just remarkable to me and how incredible it is to me that this is now in the public record. Okay, that a statement like this by Justice Barak about the importance of the State of Israel and how to remind the world of what could have been different had the State of Israel existed in 1939. Second, I am a strong believer in human dignity, right? A person who suffered at the hand of the Nazis and was hidden in a closet, essentially a closet with his mother for 8 months, witnessed the destruction of his community in Kaunas, Lithuania. I am a strong believer in human dignity. The Nazis and their collaborators sought to reduce us to dust and ashes. They aimed to strip us of our human dignity. However, in this, they failed. During the most challenging During the most challenging moments in the ghetto, we preserved our humanity and the spirit of humankind. The Nazis succeeded in murdering many of our people, but they could not take away our humanity. The rebirth following the Holocaust is the rebirth of the human being, of the centrality of humanity, and of human rights for every person. Many international instruments focusing on the rights of the individual were adopted after 1945, and the protection of human rights is also deeply rooted in the Israeli legal system. So now he makes the case for Israel, and how dare anyone claim that Israel does not abide by international law. Israel is a democracy with a strong legal system and an independent judicial system. Whenever there is tension between national security interests and human rights, the former, national security interests, must be attained without compromising the protection of the latter, human rights. As I have written, security and human rights go hand in hand. There is no democracy without security. There is no democracy without human rights. Democracy is based upon a delicate balance between collective security and individual liberty. The need for such balancing, right, and the footnotes are below. The need for such balancing has served as a silver lining in the rulings of the Supreme Court of Israel. Once, in the midst of a military operation in Gaza, that means a previous military operation, there are several that Israel conducted in Gaza over the past several years. Once, in the midst of a military operation in Gaza, the Supreme Court ordered the army to repair the water pipes that had been damaged by army tanks, and to do so while the operation was still ongoing. On the same occasion, it ordered the army to provide humanitarian aid to civilians and to halt hostilities to allow for the burial of the dead. In its judgment on targeted killings, the Supreme Court ruled that Israel must always act in accordance with international humanitarian law, and that Israel must refrain from targeting terrorists when excessive harm to civilians is anticipated. So we have a history of abiding by international humanitarian law, and the Israel Supreme Court has intervened to ensure that Israel's army and Israel's government maintains international law, and that it maintains Israel abiding by international conventions like the Genocide Convention, right? Another way of Barak saying, don't bother, this whole proceeding is a sham because we already take care of this ourselves. We have taken care of this before. We've proven it before, and we're proving it again. As a judge, as a judge in the Israeli Supreme Court, I wrote that every Israeli soldier carries with him or her in their backpack the rules of international law. This means that international law guides the actions of all Israeli soldiers wherever they are. I also wrote that when a democratic state fights terrorism, it does so with one hand tied behind its back. Even when fighting a terrorist group like Hamas that does not abide by international law, Israel must abide by the law and uphold democratic values. That's the hand behind its back, because Hamas is not following the rules and is doing whatever it wants. And Israel, because it follows the rule, is automatically at a disadvantage. And that's also a way for Barak said, you ignore this International Court of Justice. You are ignoring, in your opinion, what Hamas does. The Israeli Supreme Court has also held that torture may not be used during the interrogation of terrorists, that religious sites and clergy must be protected, and that all captives must be afforded fundamental guarantees. Naturally, as in any democratic society, some of these rulings have been criticized in Israel. Still, the public stands behind them and the military upholds them on a regular basis. Rulings of the Israeli Supreme Court, many of them based on international law, are the standards by which Israel conducts itself. One more point I want to share. International law is also an integral part of the military code and the conduct of the Israeli army. The Code of Ethics of the Israeli Defense Forces states that, and I want to go to number 8, Israeli Defense Forces Code of Ethics, additional values, purity of arms. Okay, this is, if you just Googled that, you would see this as part of the website for the Israeli army, and it's been there since the beginning. An IDF soldier will only exercise their power or use their weapon in order to fulfill their mission, and only when necessary. They will maintain their humanity during combat and routine times. The soldier will not use their weapon or power to harm uninvolved civilians and prisoners, and will do everything in their power to prevent harm to their lives, bodies, dignity, and property. Okay, so this has been, and this is now enshrined in another public document for the world to see what the Israeli Defense Forces policy is. The soldier will not use their weapon or power to harm uninvolved civilians and prisoners, and will do everything in their power to prevent harm to their lives, bodies, dignity, and property. When those norms are violated, the Attorney General, the State Attorney, and the Military Advocate General take the necessary measures to bring those responsible to justice, and their decisions are subject to judicial review. In appropriate cases, the Israeli Supreme Court may instruct them how to act. This is Israel's DNA. Governments have been replaced. New justices have come to the Supreme Court, but the DNA of Israel's democracy does not change. Okay, so that's what I wanted to share first. Then he goes into the case of the court itself and whether it had jurisdiction. It should have had jurisdiction. He talks about the armed conflict itself and just aspects, just to make sure that it's on the record for what exactly happened on October 7th and since. Okay, and right, and then we get to here, number 21. He wants to make sure, this is paragraph 21, wants to make sure that it's on public record. A few examples illustrate this well. When in other words, what Hamas does to violate humanitarian law. When humanitarian aid enters Gaza, Hamas hoards it for its own purposes. Hamas has made clear that its tunnel network is designed for its fighters rather than for civilians seeking shelter from the hostilities. Hamas has compromised the inherently civilian nature of schools and hospitals in Gaza, using them for military purposes by storing or launching rockets from and under these sites. The fate of the hostages is especially disturbing. The act of hostage taking, it's really something to see how polite Barak is in his legal language, right? You can hear, as I have been passionate with the other paragraphs, you can hear the anger that is underneath it, okay? And the passion, that the fate of the hostages is especially disturbing. What he really means is, it is shameful that the world has ignored the fate of the hostages. The act of hostage taking committed by Hamas on 7 October constitutes a grave breach of the Geneva Conventions of 12 August 1949 and is criminalized under the Rome Statute. Hamas has not provided the names of the hostages or any information regarding who is dead and who is alive, nor have they allowed the International Committee of the Red Cross to visit the hostages as the law requires. The International Red Cross has not been able to provide medical supplies to the hostages, does not know their whereabouts, and has not succeeded in securing their release. As I write, this agony has now been ongoing for 100 days. Today, 115. Okay. The state of Israel was brought before this court as its leadership, soldiers, and children processed the shock and trauma of the attack of 7 October. An entire nation trembled, and in the blink of an eye lost its most basic sense of security. Fears of additional attacks were palpable as infiltrations continued in the days following the attack. The immediate context in which South Africa's request was brought to the court should have played a more central role in the court's reasoning. While it no way relieves Israel of its obligations, this immediate context forms the inescapable backdrop for the legal analysis of Israel's actions, even at this stage of the proceedings. So now he talks about whether it was appropriate for South Africa to bring this application. South Africa seized the court on the basis of the Genocide Convention. I might be mispronouncing that word, and clearly it's a legal term that I'm not familiar with. Article 9 of which provides the court with jurisdiction to resolve disputes related to the interpretation, application, or fulfillment of that treaty, including those relating to the responsibility of a state for genocide. This does not mean that the Genocide Convention provides the appropriate legal prism through which to analyze the situation. In my view, the appropriate legal framework for analyzing the situation in Gaza is international humanitarian law, and not the Genocide Convention. International humanitarian law provides that harm to innocent civilians and civilian infrastructure should not be excessive in comparison to the military advantage anticipated from a strike. The tragic loss of innocent lives is not considered unlawful so long as it falls within the rules and principles of international humanitarian law. Right, and that's what Israel's lawyers were trying to present when it had time to present its case. One of Israel's lawyers, a lawyer for the Foreign Ministry of Israel, is a man named Tal Becker. I know Tal Becker. I've taken classes with him as part of the Shalom Hartman Institute in Jerusalem. He is a remarkable person, an immigrant with his family from Australia, and has been involved with the foreign ministry for decades. And ever since the Oslo peace accords happened and that whole process with the Palestinians, he has been intimately involved in with the foreign ministry about the legal framework for these peace accords. He's been involved in trying to come up with a legal definition of terrorism. And that's a whole other argument within the United Nations, right? The United Nations is quick to point out other terrorist groups, but is slow, if ever, to point out that Hamas is a terrorist organization, or any Palestinian terrorist organization is a terrorist organization. So that's a whole other framework of the United Nations that Israel has been arguing ever since Israel came into existence in 1948. It's an uphill battle, right? So Tal Becker made an impassioned plea before the court about humanitarian law and the innate contradiction in humanitarian law. We might assume, according to humanitarian law, that war is forbidden. That should be a principle of humanitarian law, right? That's what we would imagine when you're talking about humanitarianism, the idea that all life is sacred and that the taking of any life is a desecration of humanitarian law, because all human beings have the right to life, liberty, and the pursuit of happiness. If we apply American principles to the entire world, then we would imagine then that war is against humanitarianism, but it's not. War can be conducted legally and morally and ethically. And that the context for that is an army fights an army. And when armies battle each other, there are even rules for how they are supposed to conduct the fight. Now, when mustard gas was used in World War I, whoever used it first, the German, okay, doesn't matter, should have been brought up on charges. Any chemical weapons used in war today goes against law, the rules of war. The taking of prisoners of war. There are rules of how those prisoners should be treated while they are held captive until the end of the war, right? So there are rules when it comes to trying to make war as moral and ethical and humanitarian as possible, okay? Because wars will be conducted, okay? So we can have a whole course, a whole college course on the ethics of war. And it would be a fascinating class to understand how war was conducted, right? Read how the Greeks said war should be conducted, how the Romans said, how the Chinese said, right? 2,000 years ago, there's books that are around today about how Chinese generals said war should be conducted, etc., etc. So there are books that can be read, and you can have, there are Christian sources on how, like, Christian church fathers have written about the conduct of war. All right, so you can read about war as a military strategy, as a government strategy, as a religious strategy, right? The whole idea of the Crusades and the Inquisition, all part of a religion conducting a war in the name of religion. Okay, so all that aside, Barak says that that when the International Court of Justice looks at the issue of Israel and Hamas, it should be done through international humanitarian law and not through the Genocide Convention. Paragraph 27. The drafters of the Genocide Convention clarified in their discussions that the infliction of losses, even heavy losses, on the civilian population in the course of operations of war does not, as a rule, constitute genocide. So let me make that clear. The infliction of losses, even heavy losses, does not, as a rule, constitute genocide. In modern war, belligerents normally destroy factories, means of communication, public buildings, etc., and the civilian population inevitably suffers more or less severe losses. It would, of course, be desirable to limit such losses. Various measures might be taken to achieve this end, but this question belongs to the field of the regulation of the conditions of war and not to that of genocide. Okay, that's written here in this footnote in 1947. Heavy losses result as a matter of war. They should try to be avoided, but it doesn't mean that it's genocide. Okay, so now Barak wants to get to other cases of genocide that have come up before and how the International Court of Justice either ignored them or how they dealt with those other cases, which makes for an interesting discussion, Barak says, when it vis-a-vis this discussion about Israel and Hamas. Central to the crime of genocide is the element of intent, namely the intent to destroy in whole or in part a national, ethnic, racial, or religious group as such, right? So is Israel's army is the intent of the Israeli army to wipe out all of the Palestinian population? No, it never has been, nor will it ever be. Its intent is to eradicate Hamas, which is a segment of the Palestinian Authority, right? When France and Germany were fighting each other in World War I, was their intent to wipe off the face of the earth the nation of Germany or the nation of France? Well, maybe as the war went on, citizens were angry at the other nation, but I don't think that that was the intent of the army. The army was the intent of the war was to gain an advantage and to win. And that meant to inflict as much loss as possible on the other's armed forces. It was not part of, it's not considered genocide, even though millions of people died over the course of World War I. Okay. And I don't think in World War II that the intent of the Allies was to wipe off Germany off the face of the earth. It was to wipe out the Nazis, a segment of the German population and its army, off the face of the earth. International courts have been reluctant to establish such intent and characterize atrocities as genocide, right? In other words, a nice way of saying International Court of Justice has refused to get involved in other cases where it should have gotten involved when it was clear that it was genocide. And to make a point, a moral point, and a legal point about those cases. The International Criminal Tribunal for Rwanda was established primarily to prosecute the crime of genocide. Nonetheless, it set a high threshold for proving the specific intent required for genocide. In its very first case, the Akeyusu case, the International Rwanda Court described the required specific intent as a psychological relationship between the physical result and the mental state of the perpetrator, which demands that the perpetrator clearly seeks to produce the act charged. This high bar explains some of the full or partial acquittals at the Rwanda court. An analogous bar was also adopted by the International Criminal Tribunal for Yugoslavia. The Hutus intended to wipe the Tutsis off the face of the earth, and yet the International Criminal Tribunal for Rwanda set such a high bar that it was almost impossible to convict the Hutus of such a crime. And the same thing happened in the former Yugoslavia for the Serbs trying to wipe out the native Muslim population. The court, with regard to state responsibility, has similarly adopted a restrictive approach in cases involving genocide on the merits. In application of the Convention on Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina versus Serbia and Montenegro, the court concluded that, save in the case of Srebrenica, right, there was that one mass slaughter in Srebrenica in the Yugoslavian war, the widespread and serious atrocities committed in Bosnia and Herzegovina were not carried out with the specific intent to destroy, in part, the Bosnian Muslim group. Ask any Bosnian today, and they would argue that result. They would think, and they still think, that the Serbs were out to get them and are still out to get them. Okay? I accept that the proof of intent required at this preliminary stage is different from the one required at the merits stage. It's not necessary at this stage to convincingly show and then this Latin legal term of genocide by reference to particular circumstances, or for a pattern of conduct to be such that it could only point to the existence of such intent. However, some proof of intent is necessary, at the very least sufficient proof to make a claim of genocide plausible. Okay, so now he gets to, just a second here, right, yes. Here's what he wants to point out. What happened about Myanmar, okay, what is formerly called Burma. To understand the court's erroneous approach, that is not doing a fact-finding mission and relying on scant evidence, it's important to compare the present case to the Gambia case. application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia, that's what the country in Africa is officially known, the Gambia versus Myanmar. Provisional Measures Order of 23 January 2020. To conclude that the asserted rights were plausible in the Gambia case, right? To prove the Gambia case that genocide was going on in Myanmar, right? The Uyghur refugees, right, or whatever, I don't know how to pronounce them, but the refugees in Myanmar, or this segment of the Myanmar population that is being driven out, that are refugees, have been slaughtered. The court relied on 2 reports issued by the independent international fact-finding mission. These reports were based on the meticulous collection of evidence over 2 years, which included 400 interviews with victims and eyewitnesses, analysis of satellite imagery, photographs and videos, the cross-checking of information against credible secondary information, expert interviews, and raw data. The independent experts in this fact-finding mission that took 2 years traveled to Bangladesh, Indonesia, Malaysia, and Thailand, that's where the refugees were going, to interview victims and witnesses and hold other meetings. Furthermore, the mission's secretariat undertook 6 additional field missions. In its report of 12 September 2018, the fact-finding mission concluded that there were reasonable grounds to conclude that serious crimes under international law had been committed, including genocide. The fact-finding mission also stated that on reasonable grounds, the factors allowing the inference of genocidal intent were present. The fact-finding mission reiterated its conclusions based on further investigations in its second report of 8 August 2019. Okay, a fact-finding mission took 2 years, 400 interviews, going over several countries to interview. In the present case, there is no evidence comparable to that to the court in the Gambia case. To determine the plausibility of rights in the present case, the court relies on 4 sets of facts. First, it looks at the figures for deaths, injuries, and damage to infrastructure reported by the United Nations Office for the Coordination of Humanitarian Affairs. Second, it relies on the statement made by the Undersecretary General of that office, a report of the World Health Organization, and a statement by the Commissioner General of the United Nations Relief Works Agency, that very agency that is under attack right now. Third, it notes the statements of 3 Israeli officials. Fourth, it considers the views expressed by a group of special rapporteurs and the CERD committee. Okay, so these are bureaucrats and others and random Israeli officials that the Court of Justice here is relying on, not 2 years of fact-finding missions and not interviews with victims themselves, right? No interviews with any victims of the October 7th massacre at the hands of Hamas, none. Regarding the figures for death, injuries, and damage to infrastructure, the court omits to mention that such figures come from the Ministry of Health of Gaza, which is controlled by Hamas. They are not the United Nations figures. Furthermore, these figures do not distinguish between civilians and combatants, or between military objectives and civilian objects. It's difficult to draw any conclusions from them. The statements by the Undersecretary General of that committee at the World Health Organization and UNRWA are insufficient to prove plausible intent. None of these statements mention the term genocide or point to any trace of intent. They indeed describe a tragic humanitarian situation, which is the unfortunate result of an armed conflict, but there is no reference to the subject matter of the Genocide Convention. Furthermore, the court is unaware of the underlying information or methodology used by the individuals who made these statements. This is in stark contrast to the evidence available to the court in the Gambia case. And one more paragraph, the declarations made by the President of Israel and the Minister of Defense of Israel which the Court of Justice is using, are not a sufficient factual basis for inferring a plausible intent of genocide. Both authorities, President, Minister of Defense, have issued several statements clarifying that Israel's intent is the destruction of Hamas, not the Palestinians in Gaza. For example, on 29 October, Israel's Minister of Defense stated that we are not fighting the Palestinian multitude and the Palestinian people in Gaza. On 29 November, the President of Israel said that Israel is doing all it can in cooperation with various partners to increase the flow of humanitarian aid to the citizens of Gaza. Regretfully, the court did not take note of these statements. Finally, regarding the statements made by the Minister of Energy and Infrastructure, that's Smotrich or Ben-Gvir, who are radicals themselves and are part of the war cabinet, Israel's war cabinet, the latter is not an official with authority over the military. The relevant factual basis allowing for an inference of intent to commit genocide must stem from the organs which are capable of having an effect on the military operations. These organs have repeatedly explained that the purpose of the military operation is to target Hamas, not the Palestinians in Gaza. Okay, good for Barak. Now, okay, I want to end with these 3 paragraphs. Genocide is a shadow over the history of the Jewish people, and it is intertwined with my own personal experience. The idea that Israel is now accused of committing genocide is very hard for me personally, as a genocide survivor, deeply aware of Israel's commitment to the rule of law as a Jewish and democratic state. Throughout my life, I've worked tirelessly to ensure that the object and purpose of the Genocide Convention is realized in practice, and I have fought to make sure that genocide disappears from our lives. Had the court granted South Africa's request to put an immediate end to the military operation in Gaza, Israel would have been left defenseless in the face of brutal assault, unable to fulfill its most basic duties vis-a-vis its citizens. It would have amounted to tying both of Israel's hands, denying it the ability to fight even in accordance with international law. Meanwhile, the hands of Hamas would have been free to continue harming Israelis and Palestinians alike. It is with great respect that I have joined this court as an ad hoc judge. I was appointed by Israel. I'm not an agent of Israel. My compass is the search for morality, truth, and justice. It is to protect these values that Israel's daughters and sons have selflessly paid with their lives and dreams in a war that Israel did not choose. Incredible. And I just think it's just important to read that, important to see how it's part of the public record now. And I think it should be required reading for everyone. And tragically, of course, it's not going to be. And how many people will actually read this? How many people who are arguing against Israel, who are arguing that Israel is committing genocide, how many of them will take the time, will even know that Justice Barak sat on this panel in the International Court of Justice, let alone take the time to read his impassioned, eloquent case against genocide and for the state of Israel? Yes, Perry.
Boy, I tell you, I couldn't scribble notes fast enough during this, including doing a little bit of Google searches.
Yeah.
First thing, the word seized in that context means make the court aware. But you'll notice that they also didn't make the court aware of what Russia's doing to the Ukraine.
Well, there's that too, but that's a separate case all of itself, and that gets to politics. It gets to the politics, unfortunately, involved in a court of justice and the United Nations that it's supposed to be neutral.
Yeah. I'd like to encourage.
I just want to throw that out there too.
Oh, sure.
That's the problem that Israel has with the United Nations, that it claims the United Nations is biased and is influenced by Arab money.
I'd like to encourage everybody to read the column in the Post yesterday by Ruth Marcus, but not so much for what her content is, but online, the comments that people wrote that will drive you crazy. Yeah. Now, what's happened, in my opinion, This is a little bit like when I was studying for the bar and the bar review, the teacher came upon the phrase malice aforethought, which just riles everybody up, but yet it's not that big a deal.
Right.
In other words, it's not supposed to excite you. The same things happened here. They have hijacked the word genocide and trying to make it fit what they want it to. And as you've spent so much time explaining, it means something completely, not completely, but substantially different than is being
right.
inferred.
Israel is not committing genocide.
Yes,
Israel
understood.
is doing what it's doing because it's an act of war.
So the word's been hijacked.
Yes.
Completely. And by the way, I also was quickly looking up the international humanitarian law, which appears to be really more common law that's accumulated over time.
Yes.
I think that's important to understand that.
Yeah.
But it's such a dichotomy that here is Israel facing these charges, but yet Hamas is not subject to any UN sanctions.
Right.
Nor or the people of Gaza. Gaza is not, and it just
that's it. Yes. So the tragedy, the tragedy is how people's attention is focused on the wrong party, and that Hamas is playing into that, has always played into that, and I would argue the Palestinian Authority has always played into that, and before that the PLO has always played into that, and knows exactly how to pull the heartstrings of the global community, to pull it for the Palestinians, no matter who the Palestinians are, could even be these awful terrorists, right? And to get some to even think that the horrific atrocities that they perpetrated on October 7th were allowed because of seeking liberation just shows how twisted this whole thing has become, right? And that's why it's so important to read Justice Barak's statement, to try to add some sanity to the conversation. Bob, what did you want to say?
When this came out on Friday, I looked up what do these courts do about Syria and the use of chemical weapons. Thoughtless.
Right. Absolutely nothing. Absolutely not. Well, somebody has to bring it up, and then somebody has to be, or some country has to bring it up, and then the court has to deem it credible enough to do something about it. Right. That says a lot, right, about the government of Syria killing its own population with chemical weapons. Right. And it's clear. Yeah.
I'm reminded of the old story of, I don't know where it takes place, but let's just say it takes place in Tsarist Russia. Yeah. And an old Jewish guy is walking across the street, and the Cossacks stop the old guy and say, "Jew, who caused all the problems in the world?" He says, "The Jews and the window washers." And they go, "Why the window washers?" And he says, "Why the Jews?"
Yeah.
You've all heard that, right?
Yeah. I've heard lots of iterations of that. Yes.
It's always not equitable. And, Hamas never, but here's the other thing. Hamas never signed anything.
Right.
They're a rogue.
That's the definition of what a terrorist is. Right? A terrorist is a rogue. So, right. And it's a terrorist acts against the established government to either act against the government itself or an enemy state. So anyway, I thought it was important to share Barak's passionate, articulate statement for us to understand. Well, I'm preaching to the choir here, but if people share this recording, and I'm going to also, like I said, send out the Israel update email this afternoon with a link to this. It's important to share these links with people, college students that we know, other people in our family, friends that might not be aware of this, might be arguing the Palestinian case. Here's something else to read that is important to keep in mind. All right. So have a good rest of the day, everybody. Pray for peace in Israel.
Thank you.
Mona.
Okay.
Yeah. Have
Bye.
a good day, everybody.